Tonight, the Supreme Court delivers a unanimous decision, redefining the Second and Fourth Amendments. Our digital lives and privacy are at the center of this seismic shift. United States versus Global Data Solutions asks, what counts as arms in a digital world, and where does government power end? The Constitution must adapt to the digital age. The future of privacy and personal defense starts now. Let's dive in. To grasp today's ruling, we need to look back. The Second Amendment, ratified in 1791, has long sparked debate: collective militia right or individual self-defense. In 2008, District of Columbia versus Heller affirmed an individual's right to possess firearms for self-defense. The Fourth Amendment, born from distrust of government overreach, protects against unreasonable searches and seizures. For most of history, this meant physical things, your home, your letters. But the digital revolution moved our private papers to corporate servers, creating legal gray areas. The third-party doctrine from the 1970s said data shared with companies wasn't protected by the Fourth Amendment. That changed in 2018 with Carpenter versus United States, which ruled that accessing cell site data is a Fourth Amendment search. Two powerful legal currents, expanding self-defense rights and growing concern over digital privacy, were on a collision course. It was only a matter of time before a case forced the Supreme Court to address both at once. That case, United States versus Global Data Solutions, sparked not by a gun, but by a piece of code. The stage was set for a historic showdown. It began with a tech startup, GDS, and its software, Aegis, a digital guard dog for personal data. Aegis used AI to encrypt and decentralize user data, but also included a feature to launch automated counterhacks against intruders. GDS argued this was digital self-defense, like owning a firearm for your home. The government disagreed, indicting GDS founders for creating an illegal digital weapon. They also compelled GDS to turn over all user data, claiming the third-party doctrine applied. GDS fought back. First, they argued their code was arms under the Second Amendment, and banning it was like banning home defense. Second, they claimed user data stored with GDS was a personal effect, protected by the Fourth Amendment. The case quickly moved through the courts, with conflicting rulings. The legal storm was set. Is defensive code a constitutional right? Is your data on a server your private property? The Supreme Court would decide. The nation watched, waiting for an answer. The stakes could not have been higher. On November 6, 2025, the Supreme Court delivered its historic, unanimous opinion. All 9 justices affirmed Global Data Solutions' arguments, reshaping digital rights. On the Fourth Amendment, the court declared the third-party doctrine obsolete in a world where our lives are stored online. From now on, the government must get a warrant based on probable cause to access your data held by a third party. The court called this a digital home, a private space the government can't enter without justification. Turning to the Second Amendment, the justices ruled that self-defense extends to the digital realm. Defensive software that neutralizes attacks can be considered arms. But as with firearms, reasonable regulation is allowed, an outright ban is not. The conviction of the GDS founders was vacated, and the constitutional declarations are now law. The decision redefines privacy and self-defense for the digital age. The message: your digital life is protected, and your right to defend it is real. The legal landscape has changed, permanently. The implications are just beginning to unfold. The court's expansion of the Second Amendment to digital arms is a game changer. The right to bear arms now includes code, software, and AI. If your most valuable property is digital, your right to defend it must be digital too. This ruling creates a new industry, personal defensive cybersecurity. Expect a surge in advanced security software, AI-driven systems, automated countermeasures, and unbreakable encryption. Civilians now have the right to fight back against hackers and data thieves. But where's the line between defense and offense? The court left that to Congress and lower courts. A legislative battle is coming, with law enforcement and civil liberties groups on opposite sides. Will we see a digital arms race at home? Will the tech-savvy have an edge over the vulnerable? The debate over responsible digital gun ownership has begun. The Second Amendment is now about silicon and software, not just steel and gunpowder. The rules of self-defense have changed. The future is digital, and so are your rights. The Fourth Amendment ruling strikes at the heart of mass data collection. For years, the government bypassed warrants by collecting data from tech companies. Today, the court declared that unconstitutional. Your data on a cloud server is now legally part of your home. The justices recognize that using third-party services is a necessity, not a choice. The government must now target individuals with specific warrants, not sweep up everyone's data. Law enforcement will need new, more focused methods. Privacy advocates call this the biggest civil liberties victory of the century. Tech companies now have a legal shield. They must refuse data requests without a warrant. Expect a redesign of systems to enhance privacy. For you, it means your emails, photos, and online life are now your digital castle. The government needs a warrant to enter. Your privacy is no longer a legal fiction. It's a constitutional fact. The political fallout is immediate and unpredictable. The unanimous ruling scrambles party lines. Libertarian Republicans and progressive Democrats celebrate, while security hawks and moderates worry. Some see a victory for liberty, others fear weakened defenses against crime and cyber attacks. Congress will rush to regulate digital arms and test the court's limits. The decision challenges big tech's business model and strengthens the argument that users own their data. Expect a push for a federal data privacy law, with both parties vying to protect digital consumers. The debate is no longer just about gun control or surveillance, it's about code control and data ownership. The 2026 midterms and 2028 presidential race will be fought on this new digital terrain. Candidates must now address digital self-defense, government data limits, and digital rights. The Supreme Court has set the political agenda for the next decade. The rules of the game have changed, the digital battlefield is here, the fight for your rights has just begun. To understand this ruling, we spoke with Professor Evelyn Reed of Yale Law School. She calls it a paradigm shift, not just an evolution. The court's unanimous voice signals that old legal frameworks no longer fit the digital age. By linking the Second and Fourth Amendments, the justices created a holistic framework for liberty. Security and privacy are now two sides of the same coin. The right to digital privacy is meaningless without the right to defend it. The court grounded its ruling in first principles, self-defense and privacy, transcending partisan divides. This is about the individual's relationship to the state in an era of intangible threats. The details are left to Congress and lower courts, setting the stage for years of legal and legislative battles. What counts as reasonable regulation? What is a specific warrant for digital data? This is just the starting gun for a new era of constitutional law. The baton is now in the hands of the American people and their representatives. The question, how will we live up to these new rights? Where do we go from here? The Supreme Court has redrawn the map of our rights. Your privacy now extends into the digital world, and your right to self-defense includes code. This is a moment of empowerment and responsibility. The court has given us a powerful shield, but we must learn to use it wisely. Congress will hold hearings, introduce bills, and federal agencies will adapt to stricter privacy rules. The legal and political battles will shape how these rights work in practice. For you, the change is personal. You can demand privacy from companies and use new tech to protect your digital life. But digital literacy is now essential. Understand your tools, your data, and your responsibilities. A right is only as strong as those who exercise it. This story is just beginning. The questions raised will be debated everywhere for years to come. What do you think? Has the court gone too far or not far enough? Go to CNN.com to read the full opinion and join the conversation. One thing is certain. As of today, your rights have changed forever.